The Supreme Court chamber fell into a hushed silence as Associate Justice Clarence Thomas leaned forward, his normally reserved demeanor giving way to an unexpected display of skepticism. His deep voice carried throughout the ornate room as he addressed Congresswoman Jasmine Crockett, who stood confidently at the podium during oral arguments for Mitchell v. Thompson, a pivotal voting rights case. "Congresswoman," Justice Thomas said, an unusual edge in his voice, "your amicus brief cites constitutional precedents that seem at odds with your understanding of the 14th Amendment. I wonder if Howard University Law School has changed their constitutional curriculum since my time there." The pointed reference to Crockett's alma mater drew subtle gasps from seasoned court observers. Thomas's question, bordering on dismissive, challenged not just her argument but her credentials. Without flinching, Crockett adjusted her notes and responded with measured precision. "Justice Thomas, thank you for the question. Howard's constitutional curriculum remains rigorous. In fact, it was there I learned to distinguish between Justice Harlan's dissent in Plessy and the majority opinion, a distinction that informs my understanding of the equal protection issues before the court today." The during reference, subtle yet unmistakable to Thomas's controversial jurisprudence on race, created an electric moment. Chief Justice Roberts straightened in his chair while Justice Sotomayor's eyebrows raised slightly. Even Thomas himself seemed momentarily taken aback by the respectful yet pointed counter. Before we explore this remarkable exchange further, don't forget to like this video and subscribe to our channel for more exclusive analysis of pivotal Supreme Court moments. Jasmine Crockett's path to the Supreme Court podium had been anything but conventional. Before her election to Congress representing Texas's 30th District, Crockett had built a formidable reputation as a civil rights attorney. Her legal career began after graduating from Howard University School of Law, the same historic institution that had produced Justice Thomas decades earlier. As an attorney, Crockett had specialized in voting rights and criminal justice reform cases throughout Texas, often representing clients from underserved communities. Her methodical preparation and encyclopedic knowledge of constitutional precedent had earned her respect even from opposing counsel. This litigation background had uniquely prepared her for her current role as both a legislator and an advocate before the nation's highest court. At 43, Crockett represented a younger generation of legal minds shaped by both traditional civil rights jurisprudence and contemporary constitutional theory. Her colleagues in Congress recognized her exceptional legal acumen, which led to her appointment to the House Judiciary Committee and her selection to file an amicus brief in Mitchell v. Thompson, a case challenging certain provisions of a state voting law that allegedly disenfranchised minority voters. Justice Clarence Thomas, by contrast, had sat on the Supreme Court for over 30 years, establishing himself as its most consistently conservative voice. At 75, Thomas had authored hundreds of opinions that had significantly shaped American constitutional law. His jurisprudence was characterized by originalism and textualism approaches that often led him to reject the kind of expansive interpretations of civil rights statutes that attorneys like Crockett advocated. Thomas's own background included graduation from Yale Law School and a controversial confirmation process. Though he rarely spoke during oral arguments for much of his tenure, in recent years he had become more vocal, often challenging advocates with pointed questions that reflected his skepticism towards certain constitutional interpretations. The specific context for their confrontation was Mitchell v. Thompson, a case examining whether a state's purging of voter rolls violated the Voting Rights Act and the 14th Amendment. Crockett's amicus brief had argued that the state's procedures had a disproportionate impact on minority voters and thus violated equal protection principles. Her brief had cited several precedents, including some cases where Thomas had written dissenting opinions. In preparation for the oral argument, Crockett had anticipated skeptical questioning from the court's conservative justices. She had meticulously reviewed Thomas's jurisprudence on voting rights, understanding that his originalist approach often led him to narrower interpretations of constitutional protections than she advocated. This preparation would prove crucial when Thomas decided to focus not just on her arguments but on her credentials. The stage was set for a collision between two African-American legal minds representing different generations and jurisprudential philosophies, a contrast that would soon produce one of the most memorable exchanges in recent Supreme Court history. The Supreme Court's imposing chamber hummed with anticipation as Congresswoman Jasmine Crockett approached the podium. Although appearing as counsel for amicus curiae, rather than representing a party to the case, her brief had been cited multiple times during the preceding arguments. prompting several justices to direct questions specifically to her during her allotted time. Chief Justice Roberts acknowledged her with a nod. "Congresswoman Crockett, you may proceed." "Thank you, Mr. Chief Justice, and may it please the court." Crockett began, her voice steady and clear in the chamber's perfect acoustics. "The voter roll purging procedures at issue in this case present substantial constitutional concerns under both the 14th Amendment and the Voting Rights Act. When a state implements procedures that result in the disproportionate removal of minority voters without sufficient notice or opportunity for remediation, it undermines the fundamental right to vote that this court has consistently protected." Justice Barrett leaned forward. "Counsel, your brief argues that disparate impact alone is sufficient to establish a constitutional violation. But doesn't our precedent require evidence of discriminatory intent?" "Justice Barrett, thank you for that question," Crockett replied. "While discriminatory intent is indeed required for certain 14th Amendment claims under Washington v. Davis, the Voting Rights Act specifically addresses effects without necessitating proof of intent under Section 2, particularly after this court's decision in Thornburg v. Jingles. Additionally, the pattern of disenfranchisement here is so systematic that it provides circumstantial evidence from which discriminatory purpose can be inferred under Arlington Heights." Justice Alito intervened next. "But Congresswoman, the state has provided race-neutral justifications for these procedures, maintaining accurate voter rolls and preventing fraud. Aren't these legitimate state interests?" "They are indeed legitimate interests, Justice Alito," Crockett acknowledged. "However, legitimacy of purpose doesn't end the inquiry. The means chosen must still comply with constitutional guarantees. Here, the state has selected methods that purge voters without adequate notice, with error rates affecting Black and Latino voters at 3 times the rate of white voters. When less discriminatory alternatives are readily available, as they are here, selecting the more burdensome approach raises constitutional concerns." The questioning continued with several justices exploring various aspects of Crockett's argument. She responded with precise citations to the record and relevant precedents, demonstrating a command of the case that impressed even skeptical observers. Justice Kagan and Justice Sotomayor asked questions that allowed Crockett to elaborate on the real-world impacts of the challenged procedures, while Justice Gorsuch pressed her on textual interpretations of the relevant statutes. Throughout this exchange, Justice Thomas remained silent, observing with his characteristic inscrutable expression. As Crockett's time neared its conclusion, he finally leaned toward his microphone. "Congresswoman," Thomas began, his deep voice instantly commanding attention, "your amicus brief cites constitutional precedents that seem at odds with your understanding of the 14th Amendment. I wonder if Howard University Law School has changed their constitutional curriculum since my time there." The comment, framed as a question but carrying an unmistakable tone of dismissal, created a palpable tension in the business courtroom. Thomas's reference to their shared alma mater carried an implicit challenge to Crockett's legal understanding, suggesting that her interpretation represented a departure from proper constitutional analysis rather than a legitimate alternative perspective. Crockett paused briefly, taking a beefied, measured breath before responding. "Justice Thomas, thank you for the question. Howard's constitutional curriculum remains rigorous. In fact, it was there I learned to distinguish between Justice Harlan's dissent in Plessy and the majority opinion, a distinction that informs my understanding of the equal protection issues before the court today." Her response was multi-layered and precise, by referencing Justice Harlan's famous dissent in Plessy versus Ferguson, which declared, "Our Constitution is colorblind, but has been interpreted differently by various jurists." Crockett subtly highlighted the long-standing debate over how to interpret equal protection principles. The reference also acknowledged Thomas's own frequent citation of Harlan's dissent while suggesting that the same text could support her contrary conclusion. Thomas's expression remained impassive, but he continued his line of questioning. "Your brief suggests that facially neutral procedures with disparate impacts are presumptively unconstitutional. That's not the law as this court has established it. Perhaps you're advocating for what you believe the law should be rather than what it is?" The question contained another implicit challenge to Crockett's legal acumen, suggesting she was substituting political preference for legal analysis. Several court observers later noted that Thomas's tone carried unusual sharpness for oral argument. Crockett maintained her composed demeanor. "Justice Thomas, I'm advocating based on a faithful reading of this court's precedents, including your own concurrence in Bush v. Gore. where you recognize that disparate standards for evaluating ballots implicate equal protection concerns even without proven discriminatory intent. The brief carefully traces how the principles articulated by this court, when applied to the factual record in this case, support finding these particular procedures unconstitutional. Her citation of Thomas's own concurrence in the controversial 2000 election case represented a sophisticated legal countermove, using the justice's own words to support her position while demonstrating intimate familiarity with his jurisprudence. Thomas leaned back slightly, his expression giving nothing away. "That's a creative reading of my Bush v. Gore concurrence, Congresswoman. I wrote separately precisely because I grounded my analysis in Article 2, not the Equal Protection Clause." "You're absolutely correct, Justice Thomas," Crockett acknowledged smoothly. "Your primary reasoning was indeed based on Article 2, however, on page 104 of the opinion, you specifically stated you would also agree with the majority's equal protection analysis, which found that disparate treatment in ballot counting without adequate justification violated the 14th Amendment. That principle that similarly situated voters deserve similar treatment informs our argument in this case." Her precise citation to the specific page of Thomas's concurrence demonstrated remarkable command of his jurisprudence, the kind of detailed knowledge that even experienced Supreme Court advocates sometimes lack. Several observers later noted that Justice Kagan appeared to suppress a smile at this exchange. Justice Thomas, momentarily taken aback by Crockett's precise citation of his own words, shifted his approach. "Congresswoman, even accepting your characterization of Bush v. Gore, that case involved actual disparate treatment, different standards applied to identical ballots. Here, you're describing facially neutral procedures that happen to have statistical disparities in outcomes. Our cases have consistently distinguished between these situations." Crockett nodded respectfully. "Justice Thomas, that distinction is indeed central to the court's equal protection jurisprudence. However, the record in this case demonstrates that these aren't merely statistical disparities, but systemic differences in implementation." She retrieved a specific page from her notes. "The district court found on page 87 of the appendix that predominantly minority precincts were subject to different verification standards than predominantly white precincts, precisely the kind of disparate treatment that Bungdays implicates the principles from Bush v. Gore that we both recognize." Thomas's expression remained stoic, but observers noted a subtle shift in his posture. What had begun as an attempt to challenge Crockett's credentials had evolved into a substantive legal debate where she was meeting him on equal footing, citation for citation. Justice Jackson interjected with a question that allowed Crockett to elaborate on this point, providing her an opportunity to strengthen her argument. After Crockett's detailed response, Thomas made one final attempt to undermine her position. "Congresswoman, your interpretation would transform every voting procedure with any statistical disparity into a constitutional crisis. That can't be what the framers of the SOSA 14th Amendment intended. It was a classic Thomas argument appealing to original intent to limit the scope of constitutional protections, but Crockett was prepared for this line as well. "Justice Thomas, I share your commitment to understanding the framers' intentions," she replied, her tone conveying genuine respect rather than performative deference. "The Reconstruction Congress that drafted the 14th Amendment was specifically concerned with ensuring newly freed black citizens could meaningfully exercise their right to vote. Senator Howard, introducing the amendment, explicitly stated it was designed to give Congress power to ensure equal political rights and privileges for all citizens," she continued. "The historical record shows that the very Congress that drafted the 14th Amendment understood it to protect against subtle as well as overt forms of disenfranchisement. The procedures at issue here, which the record shows disproportionately remove eligible minority voters without adequate notice, represent exactly the kind of obstacle to equal political participation the amendment's framers sought to eliminate. This appeal to original intent Thomas's preferred. Interpretive method to support her progressive conclusion represented a masterstroke. Rather than rejecting Thomas's jurisprudential approach, she had engaged with it directly and used it to support her position. The courtroom remained silent as Thomas considered her response. After a moment that seemed to stretch longer than it actually did, he simply nodded slightly and said, "Thank you, Congresswoman," before leaning back in his chair. The Chief Justice, noting that Crockett's time had expired, thanked her for her arguments. As she gathered her materials to return to her seat, several court observers noted that Justice Sotomayor gave her a nearly imperceptible nod of approval. What had begun as an attempt to diminish Crockett's legal credentials had transformed into a substantive exchange that demonstrated her exceptional command of constitutional jurisprudence, including Thomas's own writings. Without raising her voice or displaying defensiveness, she had met his skepticism with precise citations and thoughtful analysis, earning the respect of everyone in the courtroom. The moment represented a triumph not just for Crockett personally, but for the principle that legal arguments should be evaluated on their merits rather than the credentials or identity of the advocate. In the rarefied air of the Supreme Court, where reputations are built on intellectual rigor rather than rhetorical flourishes, Crockett had established herself as a formidable legal mind. As Congresswoman Crockett departed the Supreme Court building, descending the iconic marble steps, legal observers and journalists quickly recognized the significance of the exchange with Justice Thomas. While Supreme Court arguments typically receive limited public attention, certain moments transcend the courtroom, entering broader cultural awareness and shaping legal discourse. By evening, legal blogs and social media accounts focused on judicial affairs were dissecting the exchange. SCOTUS blog, the preeminent source for Supreme Court analysis, featured a detailed breakdown titled "Congresswoman Meets Justice Thomas on His Own Jurisprudential Ground," noting, "What made today's exchange remarkable wasn't just Crockett's command of precedent, but her strategic decision to engage with originalism rather than reject it, demonstrating how historical understanding can support progressive outcomes." The following morning, major newspapers carried accounts of the argument, with particular emphasis on the Thomas-Crockett exchange. The New York Times noted, "In a court where advocates carefully avoid confrontation with justices, Congresswoman Crockett demonstrated how to respectfully but firmly counter judicial skepticism with precision and historical context." The Washington Post observed, "Yesterday's exchange between Justice Thomas and Representative Crockett represented a masterclass in constitutional dialogue across jurisprudential philosophies." Law school professors quickly incorporated transcripts of the exchange into their constitutional law and advocacy courses. A professor at Yale Law School told her students, "Notice how Congresswoman Crockett doesn't reject Justice Thomas's originalist framework but instead engages with it, demonstrating how historical understanding can support multiple conclusions. This represents sophisticated advocacy that meets justices where they are." For Crockett herself, the aftermath brought both professional recognition and increased responsibility. Her office reported receiving invitations to speak at judicial conferences and law schools across the country. Senior colleagues in Congress sought her input on legislation involving constitutional questions, recognizing her unique ability to frame arguments that could appeal across ideological divides. In an interview with the American Bar Association Journal, Crockett reflected on the exchange. "My approach wasn't about challenging Justice Thomas personally, but about engaging seriously with his jurisprudence. When we're advocating for civil rights, we can't dismiss originalism or textualism. We need to demonstrate how these interpretive methods, properly applied with full historical context, often support expansive protection of fundamental rights." Perhaps most significantly, legal advocates across the ideological spectrum began studying Crockett's approach. Conservative appellate attorneys noted how she had engaged respectfully with Thomas's perspective, while progressive advocates observed how she had used originalist arguments to support voting rights protections. This cross-ideological attention signaled the emergence of what some began calling bridging advocacy legal argumentation that could speak persuasively to jurists of different interpretive philosophies. Justice Thomas himself never publicly commented on the exchange, maintaining his characteristic privacy regarding court proceedings. However, court observers noted subtle changes in subsequent oral arguments. When Thomas questioned advocates about historical understandings of constitutional provisions, he began explicitly asking for specific citations to Reconstruction-era sources, suggesting a heightened attention to the same historical context Crockett had emphasized. 3 months after the oral argument, the court issued its decision in Mitchell v. Thompson. While the 6-3 ruling largely followed ideological lines, Justice Thomas's concurring opinion contained a noteworthy passage. "While I join the majority's judgment, I write separately to emphasize that facially neutral voting procedures that systematically disadvantage minority voters may indeed raise constitutional concerns when the record demonstrates actual disparate treatment rather than mere statistical disparities." Legal analysts immediately recognized this language as a direct engagement with the arguments Crockett had presented. More broadly, the exchange contributed to an evolving discourse about diversity in legal advocacy. as a black woman advocate engaging substantively with the court's most senior black justice across jurisprudential differences. Crockett had demonstrated that diversity in the legal profession brings not just different perspectives, but enhanced capacity for multifaceted constitutional analysis. Law review articles examining the exchange noted how Crockett's background as both a civil rights attorney and legislator had informed her approach, combining practical understanding of voting barriers with sophisticated constitutional theory. This observation prompted renewed discussions about the value of varied professional experiences among advocates appearing before the court. For ordinary Americans watching clips of the exchange, the moment represented something equally important, an example of respectful but principled disagreement in an era often characterized by political polarization. Comment sections across platforms reflected this sentiment, with one particularly shared observation noting, regardless of which side you're on, watching someone respond to skepticism with facts and historical context rather than outrage is something we need more of in public discourse. 6 months after the argument, when Crockett delivered the commencement address at Howard University School of Law, she reflected on the broader significance of her exchange with Justice Thomas. The Constitution doesn't belong to any political philosophy or interpretive method. It belongs to all Americans. Our responsibility as advocates is to engage deeply with its text, history, and principles, not just as we wish them to be, but as they have been understood across our nation's complex history. Only through this engagement can we build a jurisprudence that truly delivers on the Constitution's promise of equal justice under law. As future classes of law students and advocates studied the exchange, its legacy extended beyond the specific case or personalities involved. It demonstrated that the most effective advocacy doesn't reject alternative jurisprudential frameworks but engages with them substantively, finding points of connection across interpretive differences to build persuasive arguments for fundamental rights. The respectful yet principled nature of the exchange offered a template for how democratic discourse on constitutional questions can proceed with rigor, historical context, and mutual engagement rather than dismissal or caricature. In this way, what began as an attempt to question one advocate's credentials evolved into a model for constitutional dialogue that continues to influence legal advocacy today. Thank you for watching our analysis of this pivotal Supreme Court exchange. If you found this examination of constitutional discourse valuable, please like this video, subscribe to our channel, and share your thoughts in the comments below. For more in-depth coverage of the Supreme Court and constitutional developments, be sure to check out our other videos.